All right. Welcome everyone to the private comparative law session of the YCC conference. I'm glad that we were able to coordinate across different time zones and subject matters. We have 5 participants announced as presenters in this panel, but one of us was not able to join, so Ignacio won't be presenting today. That gives a slightly bigger time framework for each of you to present. And so based on our discussion, we will go in the order of the appearance, right, the program. So Wei-Lin will be first. We will assign around 15 minutes, 17 minutes perhaps to present for each of you. And we decided that we will allow people and the presenters to ask questions immediately after each paper. And then provided there is sufficient time at the end of the 4 papers presented, we will have a time to talk among all of us. So the only thing I wanted to invite you to do is just give us a line or two about you, specifically your background, and perhaps which institution you're coming from, so that we get to know each other in addition to knowing your scholarship. So Wei-Lin, the floor is yours. Please go ahead.
Okay, thank you. Please allow me to share my screen.
Yes, please.
Okay, hello everyone, and I'm Wei-Lin. I'm currently a JSD student at Yale Law School. My research focuses on the general comparative law, legal theory, and the family law and property law. And today I'm going to present my study on comparative research of modernization of family law in Japan and China, mainly focused on the late 19th centuries and early 20th centuries. And I will start. In the first half of the 20th centuries, Japan and China, two isolated but also neighboring to East Asian countries, endured their most radical transformations in the modern histories, or even in the world modern histories. That is, Japan transformed into a fascist regime and invaded China in the 1930s. And as to China, apart from against the invasion of Japan, also endured a Republican Revolution in the 1910s and Communist Revolution in the 1940s, which established a communist regime until today. And besides these intertwined and echoing histories of these two countries, there was one parallel underpinning those two countries during their turbulent ages, that is the family discourse. For Japan, one of their fascist legitimacy was established on a narrative of family state. The Japanese phrase is kazoku koka, which highlighted the fictive kinship between the Japanese people and the emperor. As for China, in the Republic era in the 1910s, Sun Yat-sen, the first president of the Republic of China, was titled the Father of China. And when the communist regime, when the communist revolution occurred, all peasants are from same family, and Chairman Mao is our father, is a slogan for the Communist Party, the CCP, to mobilize the peasant class to provoke the revolutions. Nevertheless, in addition to such political discourse driven by family analogy, formal legislations on family also played an essential role in these two countries when they encountered with Western powers in the late 19th centuries and begin the legal transplantations and the legal modernizations, try to build a Western-like legal systems. But it would tell us a totally different story. That is, even though the family discourse was equally applied in the political practice in both countries, their approaches toward institutionalizing such discourse, such family discourse in Japan and China thoroughly diverged. In its first modern civil code, the Meiji Civil Code of Japan in 1898, Japan preserved most of its customary family laws, such as koshuken. It is the power of the family head, the administrative power of the family head, and the katoku sozoku, the Japanese special succession of the family head and the family title, and etc. Whereas in China, under the rule by the Kuomintang, the ruling party at that time. It abolished all Chinese customary family laws, such as the power of the family head and the 宗条继承, which is a special succession form to the ancestral sacrifice in Chinese history. And the ruling party Kuomintang also downplayed the significance of the family system in Chinese first modern civil code, the Civil Code of Republic of China in the 1930s. So my study is based on this historical phenomenon and to ask a question that why do Japan and China choose divergently regarding customary family laws in their first effective modern civil code in the late 19th centuries and early 20th centuries, given that both are heavily relied on the family discourse for their political purpose in their modernizations. And they both have a very long history to regard the family as a basic social formations in the history. This research seeks to tackle this problem through a perspective of the comparative legal history and combining the legislative archives and the existing political histories. I found that the reason for their antithetical routes toward modernizing family laws was different because they have the different historical functions of their family systems, and they were in totally different context during their modernizations. And due to the time limits, I will skip the contextualization of this research. Generally speaking, this comparative study has not yet been studied enough, and I'm trying to fill this gap. So before entering into the main part, I will briefly limit the scope of the family law I studied in this research. I will focus on main three parts: the family relatives, marriage, and succession, which were the main parts of the continental legal tradition that was inherited by Japan and China from the Western Europe, especially from the Germany and Switzerland. The relatives were concerned about the constitution of the family and the power of the family head, and the marriage and the divorce concentrated on the liberty of the marriage, especially whether the children need the consent from the parents and the parental power upon the children's marriage and divorce. As to the succession, it related to the status of the successors and the principle of separating the inheritance. As to the modernizations, and here I simply use the modernization to refer that Japan and China tried to transplant the Western Europe law in the 19th centuries and to build a Western-like legal systems. And so I use the modernization here. In case you don't have the background knowledge about the modern legal history of the Japan and China, I will give a very brief sketch. And this is a very simple scenario of modern legal history of China and Japan. Generally, both those countries have endured a long struggle for codification of modern civil code. For Japan, they have a draft called the Old Civil Code, which did not effect because the opposition from the conservatives. After fierce controversy, the Meiji Civil Code was elected in the 1898, which is the first modern civil code of the Japan. Whereas for China, there are two drafts before the civil code of the Republic of China in the 1930s, which was the draft of the Qing Civil Code in 1911 and the second draft of civil code in 1926. However, due to the wars and due to the conflicts and the chaos, these two drafts did not effect at all. So the first draft comes in the 1930s, which is what I will study this research, the civil code of the ROC, the Republic of China. So here we come to the specific comparison first of the family laws in these two countries. First, the civil codes. Let's start with the regulations on the relatives. The main concern of the relatives laws was about the legal status of the children and the power of the family head and the parental power. In Japan, the power of the family head was strong, and the distinction between the legitimate child, the natural child, the child born by the concubine, and the illegitimate child was rigorously stipulated and regulated. Whereas in China, it only emphasized the duty of family head rather than the power of family head. And China also abolished the distinction between the legitimate child and the natural child. And as to the marriage, the main concern was the consent from the parents and the parental power upon the children's marriage and divorce. In Japan, on the one hand, it required that parental consent for marriage until the age of 30 for the male and 25 for the female. It was a relative high standard for the children if they want to get married, and the male child need to get the age of 30 until he could marry liberal. He could liberal by his own will. And the divorce is until the age of 25 that you don't need the consent from the parents. Whereas in China, on the other hand, the Chinese Civil Code explicitly emphasized the liberty of marriage and required parental consent only for those who are not full of age. And the full of age at that time is the 20-year-old. So compared with Japan, the standard is relatively young, and we could say very young. And the third part is the succession. It relates to the special form of the succession in both countries and the status of the successors. In Japan, the traditional succession was called katosozoku, which included the succession of the family property, the family title, and the family sacrifice for the ancestors. In this form of successions, the eldest legitimate child, the eldest legitimate son has a priority over the daughters and the natural child and other young children. Whereas in China, the parallel succession was called 宗条继承, the 宗条 successions, which only emphasized the succession to the ancestral sacrifice, and also the eldest son had the priority over others. However, when it comes to the modern civil code, apparently Japan kept such customary successions in the Meiji Civil Code, while China swept them all out. In addition, Japan still permitted gender-based restrictions on the status of the successors in the Meiji Civil Code, which is deprived the status of the female successors, and the female successors could only be the last child to inherit to succeed the inheritance and the family positions. And whereas China did not and swept out all the gender-based restrictions on the successors. Based on the aforementioned legal provisions, I summarized the three duality of values in these comparisons. For relatives, we could say it is patriarchy versus equality. Japan emphasizes the patriarchy structure by making the power of family head coercive within the state's legal framework. And China more tended to apply equality in the family. For marriage, it showed the conflict of the familism versus the individualism. Japanese marriage laws regarded marriage and divorce as a matter of family, and the Chinese peers believe that it should be categorized as individual affairs, and individuals enjoy the freedom and liberty to get married or get divorced. As to the successions, it should be the hierarchy versus the fairness. Japan restricted the status of the natural children and the daughters on the succession affairs, whereas China abolished all these customary restrictions on the status of the successors. However, if we look up to the surveys that conducted for the legislative agency and conducted for the codifications, we could see that what these two countries doing was something that was in correspondence with the social fact. Basically, the Japanese and Chinese legislators approached family laws with an altitude, as I called in the title, with expansion and the restriction respectively. The family law that was expanded in Japan was originally belonged to the ruling class, that is the samurai class in the Edo period. While what was restricted in China was the family norms that existed widely among the different social classes in the whole Chinese societies. According to the surveys on the civil customs conducted in both countries during the time of codifications, first in the 1818s, Japan Japan, there existed a wide variety of succession patterns among the commoner class, including the peasants, the urban workers, and the urban merchants, and etc. At that time, there was no strict rules on the Japanese katoku, the Japanese special inheritance forms. And the eldest son did not necessarily have priority over the daughters and the second sons. They choose their succession patterns more based on the demand of the productivity and the labor need. The service on the civil customs in China, on the other hand, shows that society, especially in rural areas, has a wide range of the systems, such as power of the family head, the succession to ancestral life, sacrifice, and etc. And the ruling party, Kuomintang, restricted the widespread customs that originally existed in the whole society. In other words, both countries made legislative choices that did not correspond to the social facts and the history at that time. The traditional family norms perceived by the Japanese legislators were not actually as widespread as they thought, while the customs that the Chinese legislators sought to abolish were exactly as widespread in the social practice. So how do we explain this phenomenon? And here we come to the analysis of their different legislative motivations. And this section will proceed according to the following 3 steps. The first, I will consider that what the historical functions of these 2 countries' family systems diverged. And second, I will see that what these legislators and political legal elites faced in their modernization times. And finally, I will combine or formation the 2 aspects to answer that how the historical customary family laws could work during the modernizations. And so, first of all, the part of historical functions that I emphasize in this section is based on the historical functions as perceived by the legislators. That is how the legislators thought their customary laws should be like. What I try to show is how legislators themselves perceive their own institutions and their own historical functions of the family systems. The analytical concepts I propose here are politically connected versus politically disconnected. The politically connected and disconnected was based on the distinction of whether the family could be regarded as an administratively affirmative agency of the state and be responsible for the administrative and political function for the state. When the family practiced as the affirmative agency, it would be contribute to the modernizations in the political elite's eyes because the family practical functions and ethical norms benefiting the centralizations. Well, when it did not, when it is politically disconnected, the family would prevent the centralizations of the state, both for its non-administrative role and its family-centered ethics. In this situation, the Japan's family historical function is politically connected, whereas China is politically disconnected. As I said before, before the Meiji period, the family norms were main practiced by the ruling class. The succession and power of the family head were historically essential for the Tokugawa regime to rule the country and keep the social harmony on the status. And the reason for it functioned well was due to the family's administrative role in the Tokugawa Edo period. Under the Tokugawa law, the family and its head, to some extent, were partially designated by the state and helped the state to wield its power and help the operation of the state's power in the local level. When it came to the legal modernizations, how such family customary norms could function in modern times naturally step into the field of discussion. Given modern context that I will discuss next, in the Meiji legal elite's eyes, the customary family laws were perceived as the merits of Japan regarding their practical and ethical functions for political centralizations. Well, the relationship between family and state in China was not politically connected as Japanese ones. where the family head was granted administrative power from the state and thus was responsible for and controlled by the state in Japan. For Chinese family heads, they were only responsible for their family and their family members. And we could read these papers wrote by the legislators at that time. Yang Du, a senator in Republic era, directly asserted that prevents the state from progressing its feudal institutions, and that prevents society from progressing its family system. Why? Because there is an abstraction in front of the individuals and the state. In the Chinese context, the emphasis on the family only made it far away from being a nexus to link state, family head, and family members together. On the contrary, it was nothing, the family system was nothing more than a hindrance to separate the state from the family heads and the family members and make the individuals become untouchable from the state. So here we come to the modern context. The modern context I emphasize is that they are in totally different context, political context. The Japan has a stable atmosphere that is established authority, whereas Chinese Kuomintang, the ruling party, still faced many competing political forces, especially the Communist Party at that time. At the time of the codification of the civil laws in the 1890s, the Meiji regime had already tamed the political dissidents and established central power. As we say here, there are so many rebels in the Meiji period, especially the Jiyuminkenwen, the liberty and people's rights movement, but it has been tamed before the civil codification in the 1890s. So given the absolute foundation of the Meiji government and the stable political atmosphere it created after settling down the rebellion, for the legislators and the political elites of Japan, their purpose was not how to attract the mass by their proposals or by their legal or by their political ambitions, but how to require support through controlling the mass through its absolute and strong power. Well, in China, the situation was not so good and totally different. The customary family laws came into the stage in such a context where the republic government needed support from the society when it faced many other peer competitors who had succeeded in attracting the mass and possessed dangerous forces to the republic government. Therefore, given its fragile authority and ability compared with the Meiji Japan, disguising itself with liberal values in the civil code on the one hand could image that the republic government itself as a progressive rather than authoritarian party to compete with other social and political groups, especially the communist party groups. And on the other hand, the republic government should thus clean up the merits of the old family systems to integrate people into the new regime and so as to especially to establish central authority. Here we can look at two representative discourses during the codification. The first one is the article published by the Hozumi Yatsuka, an important legal scholar at the Meiji period and the legislators, who looks at the European experience as a counterexample to demonstrate the possible consequence of abandoning feminism and about adopting individualism in the civil code. The problem he felt were precisely those had occurred in the early Meiji period and during the liberty and people's rights movement, such as the fragmentation of local power and the loss of central authorities. But the Meiji government had already resolved this problem period when the civil codification embarked. So the family system itself was a tool to consolidate these gains and integrate people into the new absolute Meiji regime. And for China, let's look at the decisions of the Kuomintang, the ruling party. The problem they faced, as I said before, were threatening their rule, and both in terms of the dangers of the family revolutions in the ideological domain and in terms of the political movements and the need of the collaborations with the Chinese Communist Party and the threat from the Chinese Communist Party. In such circumstances, if it emerged as an anti-feminism, as an anti-feudal party, it could, to a certain extent, attract the support of more liberal forces to consolidate its foundations. Here I will give the last conclusion of my study. In this study, I resolved why Japan and China treated their respective customary family laws differently in their first modern civil codes, given the almost the same purpose for them to transplant Western laws and establish modern legal system. By engaging in studying legislative archives and political history, this study concludes that the customary family system in Japan and China had different historical functions, and the modern context they are doing the codification or diverged, so that they made different choices regarding customary family laws. And in Japan, the family system was politically connected with the state and thus were under control by the official government in history. During the legal modernization, the Meiji regime had established its authority after sweeping out the rebellions. It was possible for the Meiji government to expand old effective customary family laws, which were once belonged to the ruling class, to all society to legitimize its power. However, when it comes to China, the family systems was politically disconnected from the state historically and constituted as a hindrance for the state centralizing power and modernizing. And in the modern context, the Kuomintang ruling party faced many competing forces, especially the CCP, and need to win the support from the West by leveraging liberal discourse. Therefore, abolishing the old family laws was a reasonable choice for the Kuomintang to disguise as a progressive party and eliminate obstructions that might potentially prevent its centralizations. And that's my report. Thank you very much. And I look forward to have a discussion and answer questions.
Great. Thank you, Weilin. So if anyone has a question, I think we are able to unmute ourselves and perhaps raise this question right away. If you want, I can call on you. This can be an option. Anyone would like to? Okay, Irina, please.
It was very interesting for me from many perspectives, and especially because you talk how the laws enacted are actually not being used in a way intended, right? But my question is, I don't know if maybe you just, the way how you present it, you don't really emphasize this elephant in the room. Because I think that the distinctions that you draw, the politically connected or disconnected, they all might be a result and not the reason actually, because of these differences between Communist Party and the fascist influence that, for example, Japan had. Because we know that the communist regime emphasized the feminist power, the right of women to work, right? Even if you look at the wall in Berlin, on the one side, women are sitting at home in Western Germany. They are not working. They cherish these kinds of family traditions, right, and values. On the other side of the wall, every woman is working and is supposedly equal to men, and through that, of course, there is no, I think, other option that Chinese government wouldn't enact laws that would allow freedom of marriage without all this like family consent and so on. While Japan was close to the was under influence of the fascist regime, which actually emphasized different traditions. So you mentioned this at the very beginning, that it were two countries with despotic regimes in a way, but I think that for me it goes through the entire presentation. That would be the main reason why in the 20th century, these two countries turned out to have such different laws despite like some similarities before. And in your presentation, you kind of carefully go around that. So I was curious. I don't really know much in family law or laws of Japan or China. Why do you make this choice? Like, why don't you talk more about this influence? Thank you.
I was just wondering, Maybe we can pick up one more question from Ernesto, and then Wei Lin, if you would kindly answer both. And this would be, I think, a better management of time on my side. Ernesto, please tell us what your question is.
Okay, thank you. I'm going to a different approach. And what I was wondering to which extent this difference could be explained by something that happened before. And this is the approach that, or the standing that Japan and China had towards Westification or modernization in the late 20th century. Japan was probably strong, proud, and more or less on an equal foot towards the West. So maybe it was easy for them to enforce and keep their customs in the code. While China in the late 19th century, early 20th century, was slightly defeated under high pressure after the, I don't know, Boxer Revolution and so on. That maybe this might explain a different attitude to Westernization. Thank you.
Yeah, okay, so thank you very much. And thanks for also these wonderful questions. And first, regarding the Urela, I might pronounce correct, sorry. Yeah, regarding to the Urela's questions. And it is definitely true that the laws and the society and the political regimes will enhance mutually, not only one dimension, not only one side. You could say that the ideological tradition and the societal traditions influence law, and definitely the law will influence the society itself and from another side. So what you said is what I want to study, and because this is one chapter of my JSD dissertations, and what I will study next is actually what you is asking is how the communist and the fascist regime leveraged this family discourse for their legitimacy and to influence their later laws. But this here, what I want to study, especially the politically connected and politically disconnected, is the historical before the modernization, or more specifically in the Edo period from the 60th centuries to the 90th centuries, and to the Qing Emperor China in the 60th centuries to the 20th centuries. So the politically disconnected and politically connected was not a phenomenon during the communist and fascist regimes, but before them happened, and in the history, because have such historical connections, so that the legislators make the different choice. And later we need to study, I will come to study how they make such choices, and then later make them and shape them become communist regimes and the fascist regimes. I guess this is what I'm going to study later. And so if I have the progress, I will present again. Thank you very much. And the Ernesto's questions, it is about the, how to say, the international status they were during their codifications. And because I didn't present the complete research of my work during the presentation due to the time limit, and the parallel of these two countries when they start codifications is that although the Japan has more economical power than the China in the 1930s, but both of them need to abolish the extraterritorialities. Both of them are half colonizations worked by the Western powers, especially by the European powers. So for them, regarding to the codifications, they are not have the power and the discursive power and the political power regarding the extraterritorialities under the unequal treaties. The Western powers ask, you need to modern laws so that we can give up our extraterritorialities, and we could let our citizens be adjudicated by your Japanese laws, by your Japanese and your Chinese judges. So for them, I don't think that the economic power or the military power will constitute important factors to influence these two regimes to make the different choices. Because to some extent, in the eyes of the Western powers, in the eyes of the France and the German and the Holland and the New Zealand and the Britain at that times, they will not differentiate between the Chinese law and the Japanese law. On some dimensions, to them, they are barbarage law. They are it has the savage laws, not the civil laws. So for me, I think that the the international status will not constitute an essential reasons for their codifications. But I thank you very much for pointing this out. And this is my answer. Thank you very much.
Yeah, thank you so much. So Ernesto, you go next. And I think you wanted to speak for 15 minutes and then have more time for discussion. So I will wave my hand to give you a sign that you have 1 minute remaining within your 15 minutes. Will it work?
Yeah, I'll try to keep it to 15.
Okay, wonderful.
If it's a little longer, I hope it's not a problem, but it should not be.
No, it's not, no. So please go ahead. Thank you, Wedin, again. Ernesto, the floor is yours.
Brief introduction. Well, I'm Ernesto, and I'm finishing my PhD at University College London, and I'm also a lecturer here. And well, the paper I am presenting today here, I will try to put forward a relatively simple idea. I want to test the hypothesis that the numerus clausus principle of property rights has a radically different meaning in civilian and common law systems, and that this difference is not explained by the well-known divergence in their property law doctrines, but by both traditions having a different approach to the role of the judge in the process of legal change. To test this hypothesis, I will take a macro-comparative approach to assess the impact of this principle in the sources of law and the legal reasoning of Germany, England, and the US. I will conclude that, in principle, the numerus clausus is, or at least should be, far more disruptive for a common law jurisdiction than for a civilian system. However, I will also submit that as a result of having developed different approaches to the use of doctrinal and policy arguments over the 20th century, such disruptive effect is far more intense in the US than in England. As you probably know, the numerus clausus is one of the most discussed topics in contemporary property law. In a nutshell, the principle holds that private parties are not free to create new property rights and must stick to a close list of standardized property forms that are prescribed by the law. The principle has been well known for a long time in civilian jurisdictions, especially in Germany. In the common law tradition, by contrast, this principle was virtually unknown, at least as such, until the late 20th century, when it started to be discussed in the US in the style of the law and economics movement. Since then, this principle has gained increasing popularity in American property theory and property doctrine. And this interest was later matched with growing interest by comparative lawyers. From a theoretical perspective, this interest has developed around two connected topics. First, its justification, and second, and to a lesser extent, its implications for the development of property law over time. In this latter context, the numerus clausus has been described by Bram Ackermans as a constitutional rule of property law, because on one side, it limits the freedom of parties to create new property forms, and on the other, it implies an institutional choice in favor of the legislator and against courts as the competent authority to develop the property system. Comparative research has been essentially concerned with the first question, the justification, mostly discussing to which extent the civilian version of the principle can be compared to the doctrine that Anglo-American scholars have coined under the same name over the last 20 years. By contrast, the institutional choice in favor of the legislator has remained largely unexplored from a comparative perspective. And that's the gap my paper aims to fill. For a variety of reasons, the 19th century continental codifications followed a basic principle holding that judges should be strictly bound by legislation. This relation between law giving and application of the law was later transferred to the emerging democratic systems, which see statutory law as a manifestation of the general will of the nation that shall not be altered in any form by an unelected judiciary. In contemporary Germany, this idea is embodied in Articles 20 subsection 2 and 97 subsection 1 of the Basic Law. In this context, from early on, continental scholarship developed methodological rules to control the judicial application of the law. In Germany, this formed a well-defined theoretical body covering, among other things, legal interpretations and gap filling. To which extent this so-called juridical method can and should constrain judges has become increasingly doubtful. Today, constitutional doctrine widely accepts that judges are allowed to develop the law by filling gaps in legislation, especially to bring all statutes in step with changing social realities. For example, the Constitutional Court held that judges are authorized to fill gaps and extend the law by means of Rechtsfortbildung, which I will simply translate as the doctrine of extension of the law. However, the Constitutional Court has also established the limits of such power. In a 2011 holding, it held that judges are not allowed to replace the justice conception laid down by the legislator with their own. The court argued that even if judges are tasked with adapting the law to new circumstances, this power has clear boundaries. Judges cannot free themselves from the sense and purpose of the law and must implement the legislative will under the new circumstances. The relation between separation of powers and judicial development of the law achieves its maximal tension in the aforementioned doctrine of the extension of the law. Since the fall of conceptual jurisprudence, there is a general agreement that judges can resort to such doctrine to fill gaps in statutory law. However, this doctrine also is subject to heavy constraints. Not any silence in a statute qualifies as a gap, and in the process of gap filling, judges must resort to the plan of the legislator immanent in the statute. Or at least the filling must result from the general principles of the legal system. Judicial extension that is not, at least indirectly, allowed by statutory law has been held to be a violation of the basic law. Despite enjoying limited discretion, German judges are still credited with having successfully adapted the old structures of the BGB to new realities. However, due to the persistent ideal that courts should not develop the law, these doctrines are normally not presented as judicial creations, but as conceptually derived from positive law. In the field of property law, courts have avoided qualifying judicially developed interests that resemble property rights in their practical effects as such. According to legal historians Franz Vieracker, this can be explained by the strong limits that the formal structure of the BGB imposes to what even a modern court can achieve in this field. Indeed, changes that implied a clear break with the original property models of the BGB have been achieved by legislative reform. For example, the strong Roman principle of accession between land and building, enacted in the BGB originally, could only be broken by the expansion of superficies right in 1919, and more radically, by the legislative creation of flat ownership or apartment ownership in 1951. In this context, the main impact of the numerus clausus seems to be only that it restricts the ability of the court to find that the non-existence of a property right qualifies as a gap, and therefore excludes the application of the extension of the law doctrine. So overall, it seems clear that within the distribution of lawmaking competences of the German legal system, the legislator is the one primarily called to develop private law, with courts having a limited role in this process. In this way, the doctrine of numerus clausus does not really seem to take significant powers away from German courts. The relevant implication here is that in Germany, what requires justification is not the restriction of the powers of the courts, but the fact that courts have actually deviated from this principle, enacting or creating rights that have proprietary effects. In common law systems, the numerus clausus operates in a different institutional context. As in the civil law, the primary function of its courts is solving disputes under the existing standards of society. However, the stare decisis doctrine also invests Anglo-American judges with an inherent authority to develop new legal rules. Thus, in common law systems, the acknowledgement of the numerus clausus principle seems to have a deep impact on the basic division of lawmaking competences, as it takes away from courts the power to develop a part of private law. Nonetheless, confirming this requires closer attention to the differences in the source of law in England and the US. The way in which English courts exercise this discretion is limited. Because England follows a stricter stare decisis, the power of its courts to disregard their own precedent is relatively weak, and its reasoning tends to adopt the form of an historical exegesis of black letter rules. Accordingly, in the field of property law, English courts tend to defer problems created by external social and economic pressure to Parliament. Probably the best contemporary example of this is the reluctance of the House of Lords to change the term of years rule of the lease, despite holding it to be, and I'm quoting here, an ancient and technical rule that produces a bizarre outcome and has no satisfactory rationale nor useful purpose, expressing its hope that the Law Commission might look at the subject to see whether there is any good reason for maintaining it. This attitude is paralleled by the historical emergence of Parliament as a dominating force in the British Constitution, and the rise of legislation as the major source of change in English law, a phenomenon that is in fact well reflected in the creation and work of the Law Commission. Thus, similar to Germany, there is not much doubt that in England, major legal reforms are for Parliament, not for judges. In property law, this is apparent in the relevance that statutory law has acquired in England, especially after the 1925 land law legislation. In this context, the principle of numerus clausus does not seem to imply a major alteration to the way in which modern English law deals with legal change in general. Moreover, the enactment of the English version of the numerus clausus in the Law of Property Act of 1925 might seem as nothing else than a very tangible chapter in the process by which Parliament gradually became the central developer of private law in England. Hence, as in Germany, in England, there might be more need to justify the judicial infringement of the principle than its existence. The American approach is different. This is not only explained by its weaker stare decisis, but by the central place that policy arguments acquired in American legal reasoning during the 20th century. There has been much discussion on the precise place policy arguments have in American law. However, following Eisenberg, at the end, policy reasons seem to always have some role in the US, either in the way rules are first established or in the way those rules are then extended, restricted, and applied. This view is reinforced by the perception of legislatures having a limited capability to provide sound legal rules for private law problems, and that in many fields, flexible judicial rules are better than legislation. Law and Economics has endorsed this view with strong normative support, grounded in seeing case law as a more efficient source of law than statutes. Accordingly, legislative reforms in the US are also said to be less frequent and harder to achieve than in England. The faith that the American law places in judges to keep property law in step with social need is apparent in the approach taken by the 2000 restatement of the law of servitudes, which replaced traditional, more or less rigid English doctrines controlling servitudes ex ante by ex post judicial tests based on open-ended terms. Considering that in the US, the judiciary enjoys a much more relevant and legitimate role in the development of private law, the numerus clausus seems to impose a far greater limitation to the inherent power of its courts. However, the American stare decisis is also weaker than the English, and the American version of the numerus clausus is essentially the result from judicial self-restraint, not a statutory decision. Probably therefore, the American supporters of the numerus clausus have been especially focused on justifying the principle from an external policy perspective that is consistent with the idea of courts developing an efficient common law. While in England and Germany, scholars have followed an internal approach that focused on its doctrinal underpinning as a matter of principle, resorting to policy arguments only to explain or to justify the occasional breach of the principle by court. To conclude, I think that this difference has a relevant implication for the way we think about the impact of the numerus clausus in the process of legal change. In Germany and England, the principle primarily tasks the legislator with creating a property system that is flexible enough to deal with changing needs and adapted to keep it in step with society. While in the US, this responsibility lies to a far larger extent with courts. Thank you very much for listening.
Thank you so much, Ernesto. Perfect timing. So I invite everyone to raise your hand or simply unmute yourself. And if you have any questions, you're guys welcome to raise them now. Lorenzo, please.
Yeah, thank you, Ernesto, for your presentation. I was wondering whether you delved into the historical origin of refusal in, I mean, on the refusal of the idea that property rights can be created and made by judges in the civil law tradition, like France, Italy, German, and so on. From what I've studied, I mean, at the very core of the refusal of this idea, there is a need to avoid that in the creation of new property rights, the aristocracy could have repossessed power and be again at the very edge of the political power, at the top of the political power. So I was wondering whether, and insofar as in the English common law and the American common law, we do not have a revolution, at least in the sense that we experienced it in the French system. I was wondering if you see this kind of aspect as a possible, plausible explanation of this divergence.
Yes, definitely. I have put a lot of effort in my research on the aspect that you're mentioning. What you see in civilian system is this very clear political decision to get rid of freedom to create property rights, like tied to the French Revolution and the same political phenomena being enacted in the BGB almost 100 years later. So it's very conscious, it's very conscient, and it's underpinned by the idea of creating like a modern market economy, an industrial economy, and avoiding feudal privileges. It's tempting to see that this did not happen in England, but the fact that it did, but as almost everything in English law, it was gradual and very hard to perceive. So you have case law in the 1830s and 1860s that enact more or less the same ideas, but the term is never coined as such, probably because feudal privileges were already abolished in the 18th century. So they were not much conscious in this, and landowners had massive political power, and this was very relevant. And probably the idea of the trust as allowing to create rights that at least have some features of property rights that are behind the veil of the trust made it difficult for Anglo-American scholars to see this. And this only reemerged like very, very late when some American scholars see that there is some rationality to this idea that property rights come in fixed forms, and they tied to modern microeconomic analysis, finding some very nice effects that it has in the market in general.
Thank you, Ernesto. William,
thank you very much.
Yeah, William has a question.
Thank you, Ernesto. Thank you for your wonderful presentations. And my question is about the proposal you suggested, that the different approaches towards the legal change on the property law. I was wondering, is it, in your perspective, is it a special characteristic, peculiarities of the property laws, or it is actually deeply rooted in the more macro and more large scale of the judicial systems of the different countries?
I think that is a very important point. In fact, that is the point I want to make, that in Germany, saying that only courts can develop the property law system is not very special, because this is the way Germans would think in general as how the law should change. It's not, of course, that judges are irrelevant, but it's very clear. Legislator is the body that has the main role in this. While especially in the US, the view would be different, where the judge is still seen as an engine for change for the law in general. And this has been fueled by the theory of the efficient common law since the 1960s, 1970s, that has reinforced this idea that the judge is a far better lawmaker, at least for private law. And the tricky thing here is that England, that one would expect to see close to the US, has moved closer to continental systems as Parliament has gained much more power over the last 150 years, and judges became more conservative. So for England, it's not surprisingly not as important from the perspective of the lawmaking competences of the courts as for the American judges.
Oh, wonderful. I think I'll jump in and try to ask a question. So it was very interesting, Ernesto, and reminded my civil law background. But I'm wondering, since I'm not in property law anymore, like what would be your solution? Much of your paper is very persuasive observation, right, of the impact, in particular, on the US system of the numerous clauses clause and the ability of judges to make law. So what is the way forward for American judges, if at all? And then I guess the second question would be like a very small one. To the extent that you're looking at cases, do you see American courts being upset that they cannot exercise their power in view of the clause? What are they telling us recently? This is what I'm wondering. Thank you.
It's hard for me to have a good vision on the case of the US because my research is focused in England and Germany, and I only have engaged with the US to really understand their approach because they have been a leading scholarly tradition in the modern discussion of the numerus clausus. So I am not deeply aware of case law in the US. But what I have seen in general is that in the US, the numerus clausus is less well known as in England, where it has become really popular over the last 20 years. You see it in every textbook nowadays. And it is facilitated because it's clearly enacted in legislation. While in the US, this is seen as self-restrained by courts. And because courts still have the control, it's they who decide about the numerus clausus, they don't see this problem. But because they decide in general not to create new property rights, they need to find that justification for this limitation. And this justification is normally consistent with the idea that having a closed number of property rights is efficient, which was massively challenged over the 60s and 70s, especially in the 70s, that having prohibiting private parties to create property rights is inefficient because party autonomy is king in the efficient allocation of resources. But I mean, Murray and Smith, who are like leading scholars in property law in the US, got with this idea that explained why it is efficient to have a limited number of property rights. And this idea has taken off and provides an argument for judges to control the system that is still consistent with the way probably American judges think about the role.
So what's the way forward?
The way forward assumes that it's a problem. I don't think that the numerus clausus is a problem. I think the numerus clausus is a good thing. I'm not sure about the US, but in other common law jurisdictions, especially in England, in New Zealand and Australia, there's a massive pressure for the creation of new property rights. Property rights are very invasive on third parties. And I think the way out is to understand that the property law, that the numerus clausus fulfills a very important function in keeping third parties safe from duties they have not accepted. And until we really understand this, we will still face the pressure for the creation of new property rights that we might see as a problem in 20, 30, 40 years when we see the impact of having these permanent duties attached to things.
Oh, wonderful. Thank you so much. And thank you for finding time. If anyone has a question, you guys can answer. Otherwise, I'll invite our next speaker. So
thank you for the questions.
Thank you, Ernesto. All right. So then I think we will move on and allow Irina to introduce her research to us. So Irina, the floor is yours.
Thank you. So to introduce myself, I'm before I embarked on the academic journey, I actually practiced corporate and finance law in Russia and in the US. So my interest in comparative law is quite utilitarian. I'm trying to use it as an instrument that would help us to develop laws in other regions or countries or states. And my research is dedicated exactly to this problem. I'm trying to create a model how to develop laws in certain countries. And traditionally, when we talk about law development, we talk about developing countries, right? Most countries in the world are now classified as developing or emerging markets and so on. But I think my model can be used both ways. And I will explain to you why. So I'm talking about legal transplantation through private contracting. And there are two ways to develop law. Law might be developed naturally and gradually from like inside of the country. So the certain rules have been developed, then they become law. And there is another way to develop law because many times a good thing is already developed elsewhere. So why waste time and other sources to reinvent the wheel, right? If it were only possible to take the legal invention, legal rules that resolve certain problems that we are interested in resolving and bring into the new market, into a place outside of the area where the law was developed and utilize it there. So the idea of moving a legal rule from one society to another generates real discussions among scholars, lawmakers, development institutions, and the views range from denying entirely the possibility of legal transplantation to arguing that it's actually a prevalent source of legal development, particularly in private law, and that it occurs without regard to any differences in the cultural, political, social context of donors and recipients. And the question of legal transplantation has important practical implications. As I said, currently most countries need some changes. They're either on a developing stage or classified or are being classified as emerging markets or transition economies. And we have many, many other terms now used to describe basically that the system requires changes, right? And we also have that at the same time, somewhere else in the world, there is a working solution that proved to be effective and helps to solve certain problems. The problem is that numerous attempts of domestic lawmakers and external powers to bring Western laws to developing countries have showed to be unsuccessful. Rather, a small fraction of transplants succeeds. And to explain to you why I see these failures happen, I need to emphasize that usually legal transplantation is done through legislative branches and through enactment of laws. So often it's a comprehensive legal statute that is being enacted that regulates quite a complex issues. Many times it's the entire code, right? Like the most comprehensive laws we have in legal systems. Rarely it's done through judicial branch when courts adopt foreign legal solutions in their decisions and it becomes law. So in other words, often legal change, legal transplant is brought from the top down and often it's forced by foreign powers. So among the main reasons for a transplant failure, scholars name differences in cultural context of recipients and countries of origins, an abrupt and overly broad manner of reforms, and a lack of demand for laws that are being transplanted. In other words, the domestic population doesn't understand or doesn't want such laws. and therefore ignores these laws, misuses them, just cannot use them because other parts of the legal system, like administrative capabilities or corruption or local traditions, prevent them from using these new legal rules as intended. Many times, local population just tries to sabotage these laws due to all these reasons. And the mismatch between transplanted rules and local conditions is even more severe when changes are implemented top-down by an authority originated outside of the recipient country. I mean by an international power. When due to certain pressure from other countries, the country decides to enact certain laws, they just do not function the way as it is intended. So I propose a model for soft legal borrowing that rethinks the role of corporate subcultures and private contracting and brings a corporate initiative to the center. So from the culture, like cultural context being an obstacle, my model tries to use culture as an ally of change. And I call it soft legal borrowing. I hope you will agree with me once I explain to you what exactly I propose to do. So soft legal borrowing occurs when corporate entities adopt foreign legal structures into their contracts. What I mean by that, a corporation takes a transactional structure that this corporation considers to be beneficial for the business of the corporation and breaks it into elemental blocks that contract law operates with. For example, who has a right to do what, who has an obligation, how risks are distributed, and finds these blocks in local law that provide the same or similar result, even if this local law uses different terminology. That wouldn't matter. We try to adapt a structure. We do not emphasize on the legal text, on words. So out of these blocks from local laws, the corporation rebuilds the transactional structure, and I will talk about enforcement a little bit later. So it rebuilds the transactional structure using local laws and concepts. So this structure is immediately adapted to local conditions because parties would use familiar to them terms. And in my work, I discuss in many details different elements of the model, but two main elements as corporate subcultures and transactions, I will try shortly to describe here, because it's important to understand why would it be generally possible, right, to take and rebuild and so on. So the agent of change, the corporate subculture, is not chosen randomly. Today, due to globalization and the fact that the corporations just obtained already attributes necessary to become an effective agent of change. They connected through global network of corporate subcultures. Just look at all of us. We're all from different countries, right? We meet despite of the different time zones, different research in countries, and I hope we can understand each other. And it happens throughout all subcultures, professional subcultures, specifically through corporate subcultures. Today, professionals from around the world have an ability to communicate and learn from each other, and a corporate attorney from one country will probably better understand the corporate attorney from another country than some legal professional, maybe from even the same country, if they work in different areas. And corporations also have the necessary resources to conduct such change. Professional resources, they usually have the highest quality professionals working for them. They have financial resources. They can involve professionals from outside, hire like law firm, hired financial advisors, and so on. And if corporation finds certain legal rules, meaning transactional structure, advantages for the development and well-being of this corporation, then you don't need to convince the corporation to follow this rule. So you don't need to try to overcome possible resistance to legal change that enactment of statutes from the top down faces usually. So the second element of the model is contracting transactions, right? Through what means corporations can actually adopt and adapt these changes. So why it's possible through transactions? Because we have less participating parties. So it's easier to agree among 2, 3, even 5 participant parties than to adapt something through legislative branch that requires usually a lot of time and a lot of people to agree on the text. And also the statute needs to be generalized, so it needs to work for many situations. And at the moment of the enactment, we don't really know how to exactly adapt this statute to local needs because we don't have this period of trial and error. That's why most transplants fail, because they lack this period of trial and error when we can adjust the statute, make it better, fit it better to local conditions, and improve. When we deal with transactions, we have constantly trial and error, and the costs of these errors are much more less than when we enact the statute. The contract law around the world tends to be flexible enough to actually allow many changes be made this way. Contract law is not that deeply rooted in culture, for example, as family law. You cannot, by enacting statute, as Vailin was showing us, change how fathers will give away their daughters. People will not listen to that. So there are certain areas of laws that are more difficult to change. The contract law, by its nature, is rooted into professional subcultures that, as I said, today are very well connected. So we today reached probably, as I believe, this stage where we can use it to our advantage. And professionals closely looking at practices of each other, of other markets. They watch competitors, how they work, regardless of the political borders. Enforcement of such contracts can be done through arbitration, or better, when it's feasible, through local courts. Since the structure is being rebuilt based on local, these elemental blocks, how I call them, the concepts would be familiar to local courts. And unless there are certain other things that prevent us from using local courts, like corruption, or maybe they're too slow, or other reasons, the impact of such change would be, of course, much higher if we could engage local courts and bring other institutions into this change to increase the impact. When it's not possible, there is always this a way to use arbitration. And so far, I guess it was difficult to believe me that it might work. So I have an example how these changes, there are many examples, these changes do work. They're just not being emphasized by scholars and practitioners. So, and as an example that it works, I want to discuss with you syndicated loans. So syndicated loans is basically loan that is being provided by several lenders, but let's say by several banks to one borrower. This is a very popular and very important instrument in the United States and the United Kingdom that allows to finance projects that would not be possible to finance otherwise. And many developing countries, they need to have an instrument that would allow them to accumulate a lot of money. If one bank, one lender is not able to provide certain amount of money, how good is to have this instrument that allows to combine few banks, share risks, and finance projects that are crucial for the economy, right? However, so far, this instrument was developed very well in the United States, and many developing countries are liking this instrument. The structure of syndicated loans is basically a usual loan. We have a borrower, we have lenders. The only difference is that we have more lenders. So the main difference will be we need to regulate relationships between lenders. It means that in order to adopt this instrument through a contract, we basically can leave aside the part that regulates relationship between the borrower and the lender, because we have Basel, we have all kinds of international already converged laws and instruments. Most banks follow the same rules when they give a loan to a lender, for example, for construction purposes. The only difference most of the time would be to regulate relationships between lenders. And it's absolutely possible to do under contract law in most developing countries today. I used Russian markets, for example, but we can take the entire post-Soviet Union area, and we can use this instrument. We can use this instrument the same way in India, in Philippines, and many other countries, because contract law does not allow to do everything, but it has quite a broad leeway to bring the changes we need. So I will not be talking more about syndicated loans. It's just an example to illustrate what I mean by soft borrowing. I write in my article more about how it works and worked, for example, using Russian market. But basically, soft approach, soft model that I propose allows to avoid challenges that traditional legal borrowing, which is done through legislation, encounters. It can be initiated faster because there is no need for a long and complex legislative process. It involves less parties, so we have less of a conflict preventing the first deals, which would allow us to learn what we need to adjust in order to be successful. It's cheaper because it's fast, and because losses in case of a failure small if we compare it with the enactment of laws, and if the law is not perfect. As I said, it's easier to make adjustments for better fit. Any transplant requires adjustments, and when we need to change something in the statute, it's almost impossible. It will take so much time that it's economically not feasible. However, to change certain clauses in the contract, it's absolutely feasible. We can do that anytime, and little by little form our new practice in the country. It also minimizes risks of rejection, because changes are initiated by a party that is affected the most. And I compared my model with three theories that describe what kinds of conditions are necessary in order for a change to be successful. And this model satisfies all these three absolutely different theories from different parts of science. Basically, it's law, it's just sociology, because we combine the proactive party with the party that's affected the most. Also because the concepts being used by the parties are chosen by these parties. They're familiar to them. We will not face this resistance that usually enactment of law faces. Most laws are not being followed because parties just do not understand them. They are not familiar with this concept. If we use professional subcultures to bring the change and corporations, we do not have this problem. And I would want to emphasize especially the power of small changes. The attitude to, in one move, to bring the change to the country and build a new market. Unfortunately, it cannot be done this way. And this attitude is very expensive and never successful. However, bringing these small changes through small transactions and then bigger transactions and then accumulate the number of such transactions is very similar with the natural development of law, meaning from down up, like the grassroots development. I also find it important to bring the changes in a way that would provide sustainable development. As examples in my article showed that many times when the change is forced by foreign powers, as soon as the pressure releases, everything goes back to how it was before. The changes do not take roots. And they also do not teach local parties, corporations, or any other affected parties to how to deal with changes, how to sustainably develop. So using foreign law as a model, it not only allows to develop the law today and to use new transactions, it also teaches companies how to adapt legal tools for own needs, how to be an initiator, how to be an inventor, rather than just to sit and expect that authorities one day will enact this perfect statute, how to be proactive, how to operate with new instruments, how to adapt them and adopt them. And eventually, little by little, it gives the necessary experience to invent new tools and develop new instruments inside of your own market instead of only borrowing, for example. So although it mimics in many ways the natural, I call it, way of legal development, meaning from bottom up, corporations have enough power and the resources, as I mentioned before, financial and professional, that put them rather on sophisticated side of the market. So I call them, I would say that this model is rather development from the middle, if you will, because I cannot really say that corporation is such a bottom. That's not any individual. They have enough power accumulated to make an impact, right? But they are not authority as we understand it in a traditional way, meaning legislative or judicial branch. And although not every change can be brought this way, I talk about private law, about contracts, and mostly about financial instruments, and many of them can be in certain ways adopted and force the development further. And I want to emphasize that not only developing countries can borrow this way ideas from Western world, like it's traditionally been considered. I believe, for example, that the US market can also borrow many good rules through corporations. Let's just look at labor law or parental maternal leave. If corporations want to keep personnel and provide certain guarantees to workers, they might include it into their contracts and documents, and it wouldn't be against local law. So it can work both ways. And unfortunately, today, scholars and authorities are predominantly focused on legal transplantation through enactment of laws and passing comprehensive reforms, which are often rejected due to their detachment from conditions on the ground. So my article draws attention to this other way, where to directs attention to the transformative potential of series of private legal transplants. And I suggest changing the tactics of bringing legal change from authority-led, inclusive, often forced by domestic foreign powers reforms to inspiring private initiative. And
Rina, you have 30 seconds to finish.
I'm actually done. It's my last sentence.
Okay.
Yeah, and it's another conversation how I would suggest to inspire this initiative. But if you have questions with regard to the model, I would be glad to hear them.
All right. So thank you so much. This was very interesting. And let's see if people have questions. We can take a couple and then proceed with our last speaker. So Ernesto, please.
I have more than questions. I have lots of comments. I think this topic is very interesting. I also come from legal practice previous, so I have seen what you see. And I agree that scholars are blind to legal developments that never reach court. And this happens typically in contracts and corporate law. And I have seen many examples as the one you mentioned. And just to mention it, there is the work of Anthony August, who has a lot of good explanation of why legal transplant happened in the field of contracts and the other areas of private law typically, especially because the mental framework of the cultures impose different costs on the transaction might interest you. But I also have some criticism here. The first is how relevant is transplant in the field of contract law? Because examples are the one you said, syndicate loans and sophisticated financial transactions typically function with choice of law clauses. So all the sophisticated aspect that you might think could transplant will happen subject to the law of New York or English law, and just the securities at the bottom level are subject to domestic law. And because you will go through a domestic court, it is as traditional as possible. So not much transplant there. Mm-hmm. And how relevant is once you leave contract law? Because as soon as you hit corporate law in jurisdictions where you don't have trusts, things change. And all the sophisticated layers of trust law are abroad, not in the local jurisdiction. So not too much transplant. So that is my two main points. I don't want to take more time.
So yeah, why not use foreign law and don't contract constantly under New York law? I do answer this question in my article. I'm glad you asked. I will tell you why I'm against that. And you mean not only contract law, but corporate. Well, I do talk about transplantation through transactional structure. I do talk about contract law, and I will hopefully tell you why, although I believe I found many instances where it can be used in corporate law. But I guess I would need to write a new article about that. So why not contracting under New York law, like everyone does right now? Because too many times it's impossible. Not only because many times for project financing, we take as a collateral land, and it must be regulated by local laws because many countries do not allow taken as a collateral land or any other like real estate immovable assets, and regulate them under foreign law. Many times bank regulations like sanctions or risks on certain countries do not allow banks to come to new markets. Biggest part of the world cannot attract financing because banks wouldn't invest money in these markets because they don't know local risks. They are not aware of the political situation. They're afraid that they will be considered as foreign investors and they will be kicked out by local authorities. The situation is absolutely different when local banks finance local projects. They know this borrower for a long time. They know practice of this borrower, which a foreign investor wouldn't know. The only thing that they're lacking is the instrument to accumulate more finances for a particular project, because project is just too big for one bank, right? And many times, unless you use local laws and local banks, you cannot finance this project, because the project is on the federal land and there are some restrictions on foreign investments, because we have sanctions, because of political risks and so on. So the myriads of projects are not being financed because of these reasons. That's a very practical concern. The concern that is I'm interested the most, the goal here is to develop local laws. It will never be developed if we constantly run to New York laws. Not every company can afford, even though we consider arbitration as a cheap option. Not every company is so sophisticated to be experienced in arbitration, to go through arbitration somewhere in New York or in Europe. It just many times is not a feasible way. What I'm trying to achieve in my article, to show that without big expenses, we can develop market, we can develop experience inside among domestic players by using an invented wheel somewhere else.
Okay, Irina, I will use my powers finally and interfere here, if it's okay.
Sure, yes.
Yes, yeah, I really appreciate us engaging in the conversation, but let's do the following. Belin, could you kindly just raise your question for Irina, and hopefully it will help for her to improve, and then we have to go to Lorenzo.
Okay, yeah, just a quick question, and it is no problem if you don't have time to answer it. Yeah, because you are just trying to propose modifications or some alternative way to the legal transplantations. And in your model, I feel very interesting. And I was wondering, like, many criticism to the legal transplantation is that the legal transplantations have the imperialist side, that one country put its own law to another countries. And I was wondering, do you have any example, or do you have thought about whether your model could overcome this imperialism, legal imperialism of the legal transplantations? Like even today, if we one company want to developing countries company want to enter the US market or enter the European market, actually they are just trying to follow the European corporation law or American corporation laws. And if you want to enter the WTO, you need to modify your local laws, which was based on the WTO's own agreement. And this agreement was elected by those developed countries, and many will criticize this is another side of the imperialism. So I was wondering, have you model thought about this? Yeah, but if it's okay, you don't answer this. Sorry.
Thank you so much, Belin.
Thank you so much.
Okay, 30 seconds, please.
I did consider that, and unfortunately, I came to the conclusion. I have an example in my article that as soon as the pressure releases, no one actually follows the rules. So people just pretend that they follow. They have, but on a formal level. That's why I wanted to bring it. I wanted to emphasize the initiative of the corporations. They need to want the change. So the imperialism, well, it probably could be and should be, but instead of just forcing either you do that or you're not allowed, they would create genuine interest in corporation, then the change would be real. Thank you so much. It's a very important point.
Thank you so much. And I did clarify with the organizers that we have the ability to pick a few extra minutes. So Lorenzo, I apologize for not being a perfect time manager here, but if you need some extra time, please go ahead.
No problem, no problem. Thank you to the YCC, and thank you to the American Society of Comparative Law. I am Lorenzo Serafinelli, a PhD candidate at Sapienza, University of Rome. I am in the last year, so I will I will discuss my doctoral thesis in the next months, which is on on a comparative approach to conflict of laws, particularly on the issue of party autonomy in conflict of laws and contracts, conflict of laws, focusing on Latin America. In this presentation, I will describe a different and alternative approach towards the idea that party autonomy is a universal principle, which indeed is an international accepted principle. But I will embark this inquiry from a postmodern perspective, which will lead us to conclude that perhaps we can see out there, particularly in the Latin American part of the world, a parallel development in respect of the other development we see in the other parts of the world. I will begin with describing sketchy the historical evolution of the acceptance of party autonomy in contract conflicts in the American continent. American continent has been an exception to the idea of the universal acceptance of party autonomy in contract conflicts since the 18th century. Both North American part of the continent and the South refused the idea that parties could choose the applicable law to the international contracts they were party to, because they both the North American and the South American ideas was that by allowing parties to select the applicable law, it would have meant to have the common law or the Western law applied to legal situations which fell under the newly acquired sovereignty and the newly acquired power upon their own territory. So it was pretty much an issue of sovereignty which pervaded all the aspects of the law, not only party autonomy in contract conflicts, but every and each aspects in the law. What happens at some point is that North American embarks a different path. They accept the idea that parties, even though with limitations, could indeed select applicable law to their contracts, the international contracts, whereas Latin American states conserve the reluctance towards this principle, at least until the 70s of the 28th century, in which we find some sort of turning point in which these states started to accept this idea and started to accept this idea in correspondence with a democratic transition and that led these states to open up to the international community and therefore to accept the idea that they were part of a broader community in the international arena, in the international context. And one of the dark side of the entrance into the international community was that these states were in some sort of way forced to accept the idea that parties could select the applicable law to international contracts. And this was particularly the case of Argentina. Therefore, we find that in the 1994, in the Mexico Convention, there is the first recognition in the American continent of the acceptance of the idea, expressly acceptance of the idea that parties can select actually the applicable law to international contracts. Indeed, the Mexico Convention had not a great success in terms of ratification, in terms of states that followed expressly those solutions embedded in the international conventions. However, we find that from 1994 to 2020, many and several states adopted and enacted laws that embrace, embed, and envision the possibility of party to select the law applicable to international contracts. Now, this description allows us to conclude, as Simeone does in a book which inspired this reflection, my reflection and this work and my doctoral thesis, that the last 50 years in particular have been a triumphant period for party autonomy. The vast majority of codifications and conventions adopted during this period have assigned a prominent role to this principle. And in this respect, we find that this description is a linear description of how these states developed and of how the acceptance of party autonomy occurred in the Latin American continent. However, what it does not say is why. I mean, the reason why we went through this openness and this development towards party autonomy. And to do so, I will embark in a, as I said before, in a postmodern inquiry. Postmodern in this respect, in this specific context, means that I try to dismantle this meta-narrative that we have assisted to a global convergence, which was pacific and in some sort of way natural towards the acceptance of party autonomy. And I will try to show how instead we have specific mechanics that have taken place in order to lead these states in the South of America to accept party autonomy. The first issue we have to address is, what question do we ask ourselves? I mean, if we ask ourselves the question of how this continent developed and how we see it right now, we conclude that in fact there is some sort of convergence. However, if we shift the question to the who question, I mean, to who analyzed this phenomenon, and on a second layer, who influenced the laws and the legal solutions in Latin America, we find a quite different response. On who analyzed the conflict of laws in a comparative perspective, we can say that pretty much these people are follow functionalism as a methodology in comparative law, meaning that they move from the idea that there is a presumption that in specific contexts, like contracts field, which is deemed to be apolitical, as Irina and in the discussion it has come up, this apolitical dimension of contracts law lead in some way states and legal systems to converge towards same solutions because there is the same problems that have to be resolved from those legal norms. But if we look at this phenomenon from a different perspective, we can say that this analysis leaves out lots of other experiences and lots of other situations in which we cannot say and we cannot establish that, in fact, contracts are completely separated from the political arena. And party autonomy in the South part of American continent is an example of that, in so far as that particular case was employed to defend sovereignty, the now acquired sovereignty, and to somehow show that contracts were interpreted and considered to be and deemed to be central to the possibility that states could evolve and could conserve their sovereignty and their independence from the kings and queens. But the other question we have to ask is, who were the people that influenced the laws in Latin American states with respect to party autonomy? These were people that were profoundly convinced that territorialism was the trend that must be followed in a conflict of laws. Territorialism established and stated that every legal situation that has some sort of link to the territory of a certain state must fall under the law of that state, irrespective of the conflict of laws. So in some sort of sense, territorialism eliminates the conflict of laws problems and the conflict of laws issues. And the second question we have to shift to is the why question. Why we find that in the South part of the American continent, party autonomy was not accepted. We some sort of already said that. I mean, in that specific context, the idea that parties could select law, the applicable law, was perceived as a threat to sovereignty. And a specific example is the Uruguayan example. Uruguay is a state, is a nation that has not a mercantile sector, a developed mercantile sector, and therefore is a consumer of transports contracts which are operated by foreign corporations and companies. And therefore, Uruguayan did not accept the idea that parties could select the law applicable to international contracts, particularly on the base that it would have meant that transportation law would have been subjected to English law or to another Western law, and particularly English law was not deemed to be proper because it allowed the exclusion of the limitation of responsibility of the carrier, of the liability of the carrier. And so it would have infringed the national interests, the national economic interests of Uruguay. And then we come up to another question that the postmodern approach can help us to explain in a better way the evolution of this continent towards the acceptance of party autonomy. There are forces that were put into motion by globalization, meaning that we do not find as Irina called them, legal transplantation that occur in a horizontal way, which meaning that these legal transplants do not operate state to state, but we have many international actors, international organizations that assume the role of agent of change. And these agents of change contributed to the idea that the acceptance of party autonomy would have been consequential for the idea that those states were investment friendly, and therefore, in some respect, that was some sort of symbol towards the idea that those states were embedded in the international community and they were cosmopolitist. And if we look at this evolution under this light, in this light, we can see that the works and the papers and the analysis that have been carried on this issue limit themselves to the understanding of how the evolution occurred, but do not address the issue of why we have right now the American continent that allows party to choose the law applicable to international contracts, but almost every in the guide to international to the law applicable to international commercial contracts, we find a provision which allow parties to choose non-state law. So we have gone from a situation in which Latin American states did not envision the possibility to choose applicable law to a situation in which those very states allow parties to choose non-state law, and this non-state law body of rules are considered to be, they can be problematic in terms of protection of interests of national interests and other interests at stake. And on the other hand, there's an argument to put out there here that is, non-state law is not required from private actors operating in the commercial arena. If we see at the statistics of the ICC with reference to the statistics of which laws are mostly applied in international commercial contracts and international commercial arbitration, we find that almost 1% in a constant trend since 1990 are contracts or disputes governed by non-state law. So the issue here is that this solution, the non-state law possibility, the possibility to choose non-state law, is not driven by a rational argument, but is driven by the idea that by allowing this, it would be a symbol that these states are really open to the international community and are embedded in this arena in which they want to be recipient of investments and they want to attract investments from foreign foreign actors. And to conclude, so the idea is that, and those are the arguments I take in the paper, is that if we look at the phenomenon under this perspective, and if we could extend the approach to other sector of conflict of laws, the comparative methodologies could give a better insight of this field, and particularly can give the idea that this is not a set of rules that is neutral, that is value-free, but it indeed embraces value and at the very core. Thank you.
Well, this is actually great. I touch on these issues as part of the class that I teach, and I haven't gone into the historical analysis. Like somehow, today you assume that it's given party autonomy and its acceptance, at least in the United States and the European Union and also Eastern Europe. So it was very, I personally benefited from listening to your presentation. So we have a hand here. Should we call on Simeon? Please, Simeon, we can't see you, but the floor is yours.
Okay, now you should see me, maybe. Yes. Can you hear me?
Perfectly.
Okay. Well, first of all, let me say that as the only old person that attended your meeting and all the other meetings today, I want to congratulate all of you for the excellent quality of your papers. Congratulations, cheers to you. You are the future of comparative law. So now I really like all papers. I have, my knowledge is uneven with, depending on the subject. I happen to know a little bit more about Lorenzo's paper. If you give me 1 minute, I will say that, first of all, Lorenzo, you and I do not disagree. It is simply that I was doing something else and you are doing something else. And, when it comes to explaining why some countries reject party autonomy or restrict it more than others, sovereignty and territoriality is one explanation, which is indeed valid for South America at the time. But even at the same time, there were other explanations. For example, in the United States, the reason for rejecting it was the positivistic philosophy of Joseph Biel. And that suggests that, so it can be positivism, it can be authoritarianism, it can be paternalism when, for example, you restricted and exempt consumer contracts or employment contracts or other contracts involving presumptively weak parties and so on. And so now, moving forward to today, I think you have good explanations as to why the change has happened in South America. And again, I don't disagree with you. The reference to non-state law, again, I accept your explanation, but I happen to know a little more because I was in the Hague conference when we were drafting the Hague Principles on Choice of Law for commercial contracts. And I was talking to a lot of Latin American delegates, and there are some other explanations as to why they are so enamored with this principle. Most of them, I should say briefly, without disclosing any confidence, that most of them come from the arbitration field, where the use of non-state terms has been going on for forever. And so that's part of the explanation as to why they were so open to this idea, whereas people like us in the rest of the world were saying, well, not so fast. Arbitration is one thing, litigation is another. But sorry if I have taken too much time, because I know you don't have a lot. So again, congratulations to all of you. Keep up the good work. I'm proud of you.
Thank you so much, Simeon, and thank you for staying until the very end. So Ernesto, the floor is yours.
Thank you very much. It's a very interesting topic. It happens that I am a Latin American lawyer, so maybe I have an interesting insight for you. The question I would make to you is, what are the sources you're looking at? I don't know much of this subject except of my own jurisdiction, which is Chile. And what I have read from our case, the story would be slightly different. So at the time of codification, there was not a great decision that we want to exclude choice of law of foreign jurisdictions. That was not on the mind of the drafters. They were only concerned about enacting territoriality principle. So we don't have, like original codes did not have like developed conflicts of law rules. They just have rules saying domestic law applies here, domestic law applies here, domestic law applies here. And the only clear conflicts of law rule is the one on succession that says succession is governed by the last domicile of the deceased, not domestic rules. And what I have read is that at least the Chilean civil codes simply does not have a clear decision on choice of law. And the decision was never made. I'm not sure if you have probably seen the Bustamante Code, which should be at least the governing law for conflicts of law for most Latin American countries. But the way it was like accepted as a treaty was full of reservations. So it is subject to previous domestic law. So it did not change much what happened. And what I have seen as a practitioner is that you see that the court will normally upheld almost any choice of law if there is enough connection with no animosity. And the reason why in practice the judge will not uphold your choice of law is because he or she does not know the foreign law and doesn't feel comfortable with the problem. So just for realism, judge would say, yeah, this will not work here, and I apply Chilean law. And you see this, for example, when you apply uniform law, the judges somehow find a way to not apply the CISG and apply the commercial code or the civil code. But it's just because of realism, not of any ideology. That's my brief comment.
Lorenzo?
Thank you, Professor Simonides, and thank you, Ernesto. You know, the only source I have on Chilean civil code, I mean, I know that Chilean civil code has not a specific provision on that. The sources I have read comes from a writing of Bello, which wrote when he was in the UK, in England. He wrote Principios de Derecho Internacional, in which we find a brief passage on it, which in which Bello says that he is contrary to the idea that parties can choose the law applicable to international contracts. And from that, it was inferred that Chilean civil code was a territorialistic civil code in respect, with respect to the international contracts issues. And insofar as Chilean civil code influenced many states in the Latin American continent, these states have been deemed to be contrary to. And in this, I don't know, I haven't gone through the cases in Chile, but I have some insight of other cases in which we find at least until the 1970s courts that says that they are not willing to accept the idea that parties could choose the applicable law.
If you read in Spanish, there is an article that's relatively recent, about 10 years ago, where someone addressed exactly your topic. Mm-hmm. And it's very interesting. If you read in Spanish and you drop me a line, I can find the paper for you and send it.
Yeah. Thank you.
All right, then. Well, I would like to wish Lorenzo best of luck in defending his PhD in the coming months. And on my side, I would like to say it was truly a pleasure. You know, I've been involved with the YCC for a few years now, and you often hear that we don't have enough people doing comparative law on the private side. Somehow, you know, people who do, I don't know, comparative constitutional law, they always prevail. And today, I think we have had an incredible panel. I'm glad to see that there are people who are writing in this field. And I would like to encourage everyone to join the YCC or at least attend our events that will be happening during the coming years. So once again, congratulations, great papers. Thank you for sharing and spreading the word, and enjoy the rest of your weekend.
Thank you very much.
Thank you very much.
Thank you, guys.
Thank you. Bye.
Bye-bye.
Bye-bye.